This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Todd Lutsky joins us now for Ask Todd, which is your chance to ask Todd your estate planning questions live on air right now. Phone lines are wide open, all clear for you at 888-205-2263. That is the number to call to ask Todd your estate planning questions right now on air. Again, 888-205-2263 is the number. One more time. It is 888-205-2263. A reminder, we can usually get through a couple calls, so make sure that you call early in order to get in line to speak with Todd right now. That number again is 888-205-2263. Mr. Lutsky, how are you doing today?
I am doing great. How about yourself?
Good. I was out at the bar the other night.
Yeah?
And this Mobius strip walked in. And it was crying, and the bartender said, "Hey, what's wrong, buddy?" And the Mobius strip goes, "Where do I even begin?"
That's true.
And it was very sad, very sad. Todd, I want to talk to you about estate taxes within the concept of naming beneficiaries.
Yeah.
Is there anything that people can do as it relates to beneficiaries, either on investment accounts, insurance products, or anything else, that can help with estate taxes as far as how they're naming those bennies?
Yeah, I think you need to think about a lot. You have to think about all of your assets, really. So when you're doing your estate plan, you know, if you're dealing with and by the way, the answer will vary depending on whether it's a revocable trust situation or an irrevocable trust situation. So there can be some differences. But, you know, like if you're funding your revocable trust, you probably want to change the owner, not necessarily the beneficiary, right? So the owner on your bank accounts, the owner on your investment accounts, the owner on, you know, I guess that's it, brokerage investment accounts, bank accounts, CDs. The owner can be the trust. Don't really need to get into beneficiaries, really, because you want it to be owned by the trust, and then the language of the trust is going to sort of dictate where those assets go. So, for example, I had a client who was convinced all they needed, they were not married, but they had certain people that they wanted to take care of and certain nieces and nephews, etc., whole laundry list of people. And they said, all we really need to do is name beneficiaries. We don't need to bother because we're married, but we don't have any kids. I said, well, then you're going to have to run around and make sure that, you know, if you spend money out of one account and then spend money out of another account, and then that particular person who was a beneficiary on that account doesn't get anything, and you got to keep track all the time of where the money is. I mean, that's just not helpful. But if you just put all those assets in a revocable trust, now spend whatever you want to spend, because everybody in the trust will benefit from every dollar that's in there from every account. Right? And it's great. You don't even name dollar amounts. You name percentages. So if the tide rises, everybody gets a little more. If the tide shrinks, everybody gets a little less. So it's a wonderful way of doing it. It's easy. It's simple. Change the owner. Don't need to worry about the beneficiary. Not for IRAs. Not for 401ks or any qualified retirement account. And now, by the way, for an irrevocable trust, it's similar. To the extent I'm putting things in the trust, I don't need to name a beneficiary. I need to just change the owner. However, for IRAs and or life insurance, you want to think, if you're concerned about protecting assets from the nursing home, then you need to think about naming the beneficiary of those items something. So revocable or irrevocable, the beneficiary of an IRA is generally a spouse, and the contingent is generally kids or a trust. You can name a trust a beneficiary when you die. If you're concerned about nursing home planning and you want to protect the asset from a nursing home, then there are ways and times and rules, but you can name the estate the beneficiary of the IRA first ahead of the spouse and get all kinds of other nursing home planning benefits. So much to talk about. It was a great question, Chuck, but I can't even. That's just tip of the iceberg.
Talking with Todd Lutsky from Cushing and Dolan. You've got questions for Todd. This is your chance to ask them. 888-205-2263 is the number. We do still have room on the phone lines, so get calling to ask Todd your questions right now, because we're going to take a quick break, and then it is right to your questions with Todd. That number is 888-205-2263. One last time, that is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, let's get right to your questions with Todd Lutsky. First up, we've got Anna in Massachusetts. Anna, what's your question for Todd?
I'd like to know, when both spouses have an irrevocable trust and the first spouse died, how does the second spouse have access to the past or the deceased spouse's assets? How does that work?
So are you suggesting that we have a married couple and they're doing one joint irrevocable Medicaid type trust, nursing home protection trust, or are we doing two separate trusts, one for husband and wife?
Each spouse has their own irrevocable trust.
Got it. And is the irrevocable trust designed to protect assets from the nursing home? I assume, right?
I don't know about that. It's just I don't want to care about that. I just want to know, when the first spouse dies, if I die tomorrow, does my husband have access to the assets in my trust? Okay.
So first and foremost, just to help everybody understand that you would never do an irrevocable trust for to keep control over it if you're giving things away outside your estate. So I assume the value of this estate is probably under $5 million, correct?
Yes.
Okay. So then you folks would be doing, probably, if you don't care about nursing home, it would be a revocable trust, and it would be joint. But to your question, even if it's a joint revocable trust while you're living, and that wasn't your question, you're both in control, but then let's say your husband dies. And then how would you have access to the assets that are in this once joint revocable trust that now automatically becomes irrevocable? That's correct. So as soon as one dies, it becomes irrevocable, and the surviving spouse, let's say it's you, Anna, would become the trustee. So now you are the sole trustee, when before it was you and your husband. And so now that you're the sole trustee, you read the language of the trust to determine the access that you have. So with a revocable trust that is now irrevocable, there'd be two buckets in there. Probably two, maybe three buckets. A marital share, a state marital share, and a remainder share. And then these buckets are going to be filled with the assets that were in the overall joint trust. So if you had $3 million of stuff in the trust when you were alive, that $3 million is now sprinkled between these three buckets, column A, B, and C. The trustee of which is Anna. So you're in charge, Anna. And then you need to read the language. So if it's $3 million, I can tell you that $2 million would be in the C bucket, and $1 million would be in the B bucket, and the A bucket would be empty. That is driven by the value, by the estate tax laws that are in place. So in Massachusetts, you can shelter $2 million each. That's why the $2 million ended up in the C bucket, because it equals the mass exemption, and the amount over the $2 million, but under the the 13.9 million would end up in the B bucket. So that's why the $1 million is there. Now, Anna, you're probably saying, okay, there's $3 million there, Todd, but what can I do with it? Well, you're in charge. You get to take you manage it, you invest it, you buy and sell stocks and bonds, you buy and sell real estate, and you can take out all the income because the trust says you're entitled to the income. And it says you can take out the $3 million, which is principal, but you're supposed to take it as you need it to maintain your standard of living that you enjoyed when your husband was alive. Follow those rules. The assets are still yours, but the design of the trust will shelter the assets from estate taxes. So big answer to your question, but I wanted you to hope that helps. Hope that helps everybody. But folks, that's not the only items we talk about. That's great for what's in the trust, but the guide we're giving away deals with life insurance and IRAs, which are a little more complicated because they can't go into the trust right away. So if you're concerned about nursing home planning and you're married, right, this guide is for you because it offers guidance on how to protect an IRA. Well, basically naming the estate the IRA beneficiary is going to help you with not only life insurance, but with IRAs. It will provide nursing home protection. It will shelter from the costs of estate taxes, and it will be done without providing adverse income tax consequences. And that's the real wild card with IRA. So learn how to do this, folks. If you're doing estate planning and concerned about the nursing home, call and get this guide, 866-848-5699 or legalexchangeshow.com, 866-848-5699 or legalexchangeshow.com.
Let's go now to Norman in Portland. Norman, what is your question for Todd Lutsky?
Oh, hi. I was wondering how I tell if the transfer on death language has been transferred to the financial institutions that are in my revocable trust. And the lawyer said the girl Friday would do it. And I was just wondering if she ever did. And I guess I should just call, but is that what you do?
Well, let me ask you a couple questions so I can follow this. So, Norman, are you married?
Yes.
And you did a revocable trust, you and your wife?
Yes.
Okay. And the revocable trust needs to have assets put in it. That's what just so everybody understands what we're talking about. We're suggesting that you fund the trust with your brokerage account, with your bank account. And I totally agree. And funding the trust, I would stay, if it's a revocable trust, like what Chuck was asking earlier in the show, I would stay away from transfers on death. There's no need to do that, right? Why not just change the owner on the account, on the bank account, on the brokerage account? Make the owner the name of the trust. So like if I've done a trust and I'm married and it's a joint revocable trust, the name on my brokerage account will be Lutsky Family Trust. Bank account, Lutsky Family Trust. And then you don't have to worry about who the beneficiary is because the trust owns it, and the trust's language will say where all the assets of the trust go when you die, right? So if we both die, my wife and I, everything is equally to our kids, well, everything that's owned by the trust will be divided amongst the children, and you're completely covered. So that's probably my advice. And yes, to your question, yeah, call them, ask them if they did it, or send a statement to you. The next statement you get, take a look at it and see if it says, Norman Family Trust or whatever the name is on your trust. If it says that, then you know that particular asset is in that trust.
Todd, we were talking earlier about beneficiaries. Any last items that you want to add as it relates to that earlier conversation we were having?
Yeah, and again, it's kind of good to talk about the Norman case, right? He was just talking about doing that, right? So that's how you do it for revocable trusts. And we talked, it's similar for an irrevocable trust, but kind of like, I think the wild card is what this guide is really all about, and it's the IRAs of the world and the life insurance policies of the world. So, folks, when you're dealing with those, if you're thinking about nursing home protection, instead of making the life insurance policy, you never change the owner, you don't need to, but you change the life insurance beneficiary. Instead of putting it in the trust, you might put it into the estate of kind of what we were talking about. And that way it will flow into this testamentary trust and be protected for the surviving spouse from nursing homes, but at the same time allow access to it and shelter it for estate taxes. So those are the tricky assets.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.